The title of this video is Islamic Law, Global Governance, and the Burden of Contracted Debt. In the project to construct a system of global order, Islam is usually viewed in two ways, one positive, one negative. For example, when Islam is seen as a religion, it is often commended as being part of the Abrahamic tradition along with Judaism and Christianity. As such, its teachings are thought to be compatible with a unified global religious culture. However, when Islam is viewed in its legal dimension, it is often condemned in the strongest possible ways. It is said that the tenets of Islamic law, if not eliminated, must at least be modified, reformed, and brought into compliance with Western techniques of legal rule. This is especially true in the realm of human rights and the status of women. But even though Islamic law is almost universally condemned in the West as being backward, regressive, and even barbaric, it has one tenet in particular that makes it incompatible with the legal architecture of global order. Ironically, that tenet may have little to do with the inflammatory topics normally associated with Sharia law. Instead, it appears to be a rather mundane and prosaic aspect. This is the prohibition against charging of interest on debt. What in Islam is called riba is viewed as a grievous infraction. But that prohibition may be the single greatest obstacle to global order posed by the many practices of Islamic law. This seems ironic because the practice of borrowing and lending seems basic to our economic existence. The charging of interest provides an incentive of profit to offset the risk involved for the lender. Furthermore, the project of global governance is constructed on a parallel hierarchy of institutions, legal and economic. They provide the framework within which global production and wealth creation occur. In fact, however, the Islamic perspective on debt and interest may have more to do with avoiding relations of superiority and inferiority, of coercion and submission. In that tradition, for example, instead of borrowing money at interest, a person of wealth might partner with a person of enterprise. They share in the risks and rewards of a common venture. They eventually conclude their partnership by agreed upon terms. That approach is inherently more egalitarian and more personal. It is also more concerned with mutual benefit rather than personal advantage. Such a tradition tends to keep wealth active, not hoarded, while providing a social good. It tends to a diffusion rather than a concentration of wealth, as it encourages innovation and productivity. Nor does it require the mediation of an institution. Most of all, it prevents the subordination of one person to another, or the subordination of a person to an institution by the impersonal obligation of contracted debt. In fact, Islam operates on the principle of cooperation rather than competition. At the same time, the Quran sets forth clear practical requirements for partnership, for repayment, and fairness. By contrast, in the West, the charging of interest on debt is not only the most direct and efficient way to profit from assembled capital. Contracted debt can also be one of the most effective and efficient methods of imposing economic and legal order. A contract, for example, might be seen as having weight equal to a legislatively enacted statute. It can have the full force of law behind it. Individual persons are not only bound by financial obligation, they are also compelled by judicial authority. It might be argued that few initiatives to construct a system of legal order could be more effectual or more easily applied than a worldwide extension of immersive debt. By the use of advanced technology, institutions at a very high level are able to reach down to virtually every individuated person on the face of the earth. One effect of contracted debt, therefore, can be to impose by force a hierarchy of relations between borrower and lender. In Western practice, this is usually between the unequal parties of institution and private person. As such, it fits easily within the hierarchical structures of finance and governance. Whatever its intended purpose, it can also fix relations of dominance and subjection in accord with the larger purpose to construct a global rule of law.